legitimate business, legal, personal reasons. But anyway, when they came to get Eric Snowden's email, they didn't ask just to get his email. They said they wanted the encryption keys for their entire business. See, this is a problem. You have to realize the zealots who don't seem too concerned with your privacy rights. Imagine what they're going to do if they say to Apple, we don't want just the encryption or you to let us in one time to see John Smith, who we think is a terrorist. We want you to let you in all of our products. If they force a good company like Apple to do that, who in the world would want anything from Apple anywhere in the world? There is a danger that we will destroy great American companies by forcing this surveillance into their products. Senator Wyden has also made a good point. If the government is going to mandate backdoor access to the code source, and the government's going to say that Facebook or Google has to let them in a backdoor, that's a window. That's a breach of the wall. It's a breach of protection. And Senator Wyden and others have made a good point. He said, if you do that, you're actually weakening these companies to attacks of cybersecurity. Because if somebody can get in, somebody else who's smart can get in as well. So there is a danger to letting the government in. There are dozens and dozens of these programs. The NSA has something called the Dishfire database. Stores years and years of text messages from around the world, which might be fine, except for it ends up trapping people who are also American citizens as well. It ends up tracking and trapping purely domestic texts that are retransmitted outside the country. They have a program called TrackFin that collects and accumulates gigabytes of credit card purchases. I don't know, for some reason, I'm more appalled by the credit card purchases than I am the phone, because I think of all the stuff you can buy with your credit card and what it indicates about you. With phones, you can find out a lot with people's phone records. I mean, I think when the Stanford students looked at phone records, they found 85% of the time they could tell your religion by looking at your phone records. The vast majority of the time they could tell your doctors. The vast majority of the time they could tell what disease you had. Vast majority of time, the government can then also connect you through social networking and tell an extraordinary amount about you. But with a credit card, it's even more explicit than that. They can tell, do you drink? Do you smoke? How much? What magazines do you buy? What books do you read? What medicines do you take? All that's on your credit card. And we're more and more that society. We're less and less a society of cash and more the society where everything's on paper. That should worry us. It should worry us that the government has access to all of our records all of the time. It should concern us that the government also says, when you ask them, and this is an important point, that your records, when held by a third party, are not protected at all. Now, it's debatable whether that's true or not. I think it needs to be looked at again by the court, and I think there are those who will in the court say that your third-party records are. The Maryland decision was 6-3. Justice Marshall felt that your third-party records should be protected. He specifically mentioned that there was a potential stifling effect for association. There was a potential stifling effect for speech. And he was quite concerned that the government really should have a warrant to look at your records. My hope is that someday the Maryland versus Smith case is relegated to the dustbin of history in the same dustbin that we put Olmstead in. In Olmstead, they said you couldn't have any protection for your phone records. Went on for 40 years. I think we still live with some of that because we've trained and taught the phone companies not to be great advocates for your privacy. And there doesn't appear to be seen a great deal of fighting on the part of the phone companies in advocating for you. Some of the internet companies have begun to step up. But I'd like to see both phone companies and internet companies stand up and say, we're not going to do it. We're not going to give you access to us, and you're going to have to take us all the way to the Supreme Court. If we did, if there was unified resistance among the consumer and among the companies to say, we're not going to let you have our data without a fight, and that you're going to have to prove suspicion, and that you're going to have to get a specific warrant, I think then we might be able to get back to a more constitutional scenario. There have also been, within the NSA, evidence of installing filters in the facilities of internet and telecommunication companies, serving them with court orders and building backdoors into their software and acquiring keys to break their encryption. If this becomes the norm, you can see how people will flee American products, and people will say, I'm not going to use American things. There's an enormous, beyond imagination, economic punishment to our country that is occurring now and going to continue and worsen if we don't wise up and send a signal. So for those in this body who say, we need to collect more information, we're not getting enough information, warrants be damned, I don't care what they do, take all of my information, get as much as you want, those people will have to explain why they're destroying an American industry and why people around the world are going to say, we are alarmed at that and we want some protections. If we're going to use American products, if we're going to use American email, we want to know that there's not going to be indiscriminate collection of our information. Bill Binney was probably, or is probably, one of the highest ranking whistleblowers from the NSA. And the things he has to say should disturb us because he probably knows more about this than any of us will ever know. Bill Binney said that without new leadership, this is in our intelligence agencies, new laws and top-to-bottom reform, the agency, the NSA, will represent a threat of turnkey totalitarianism. The capability to turn its awesome power, now directed mainly against other countries, will now be turned on the American public. Originally, all of these intelligence forays were to get foreigners, and we lowered the standard saying, well, they don't live here, these are potentially terrorists, so we're going to have a lower standard. And they started out as foreign searches. In fact, the NSA was originally intended to search for foreigners and to search the information of foreigners. And I'm not opposed to that. In fact, I was on one of the Sunday morning programs this week, and they said, well, are you for eliminating the NSA? And I said, of course not. I'm for the NSA. I want the NSA to do surveillance that will help to protect us from attack. Not only am I for surveillance, I am for looking as deep as it takes. But I want some suspicion. I want suspicion that this person, this John Doe, that there's some evidence. You don't have to prove that they're guilty. You just have something that points towards them being suspicious. You go to the judge, and the judge says, here's a warrant. And if there's evidence that the people he called are suspicious, go back to the judge, get another warrant, go deeper and deeper. There's no reason why this couldn't be done nearly instantaneously. There's no reason why it couldn't be done 24 hours a day. And there's no reason why we can't have security and the Constitution as well. This battle has not been just about records. It's also been about another key part of the Bill of Rights, which is the right to a trial by jury, the right to due process, the right of habeas corpus. The Fifth and Sixth Amendment I see together as sort of the amendments that are with regard to your person and with regard to whether or not you're treated justly by your government. As we became fearful of terrorists, we said, well, we're just going to capture people and we will just hold them indefinitely. Now, it's one thing to catch someone on a battlefield in a foreign land shooting at us. And I've said repeatedly, people in battle don't get due process. But people outside of battle, particularly American citizens, should. But in some of these cases, we're talking about American citizens accused of a crime, perhaps terrorism, caught in our country. And we're going to say, well, they don't really deserve trials. They don't deserve lawyers. In fact, one senator said recently, and I find this really hard to believe, he said, well, when they ask you for a judge, just drone them. Ha ha. Same guy said, well, when they ask you for a lawyer, you just tell them to shut up. About 10 years ago, Richard Jewell was thought to be the Olympic bomber. Everybody said he did it. TV convicted him within minutes. Everybody said he was the Olympic bomber. He fit the profile. He wore glasses. He was an introvert and he had a backpack and he seemed real helpful. Somehow that was the profile. Everybody said he did it. The only problem was he didn't do it. So here he was accused of being a terrorist, of exploding something, doing something terrible, killing innocent people. And I think to myself, if he'd have been a black man in the South in 1920, what would have happened to him? Or if it had been any American in this century, if the people who believe in no jurisprudence were really in charge, we should be afraid of ever letting these people get in charge of our government. Because the thing is that Richard Jewell was innocent. People say, well, these aren't just American citizens, they're enemy combatants. And we don't give any kind of jurisprudence, no judges, no lawyers for these people, they're enemy combatants. Well, it kind of begs the question, doesn't it? Who gets to decide who's an enemy combatant and who's an American citizen? Are we really so frightened and so easily frightened that we would give up a 1,000-year history? Magna Carta, even before we had juries, even in the Greek and Roman times, we had juries. Are we really willing to give that up? Give people a classification that the government assesses them, cannot be challenged. People don't get a lawyer. They don't get presented to the judge and told why they're being held, and we would hold them forever? And the response I got during the debate over this was the debate over indefinite detention. The response I got was, well, yeah, we would keep them. We'd send them to Guantanamo Bay. An American citizen? Sure, if they're dangerous. Kind of begs the question, doesn't it? Who gets to decide who's dangerous and who's not? When this finally made it to the Supreme Court, though, and whether or not you can hold an American citizen, the Supreme Court rejected the administration's claim that those labeled enemy combatants were not entitled to judicial review. It took years and years to finally have the Supreme Court tell people that the Bill of Rights was still in effect. That if you're an American citizen accused of a crime in our country, no matter how heinous, you do have a right to a trial by jury. You do have the right to a lawyer. You do have the right of habeas corpus. You do have all of the rights of an American citizen. And that no one can arbitrarily take those away from you. And if you don't think that that's potentially a problem, think of the South in the 1920s. Think of what would have happened if Richard Jewell were a black man in the 1920s. He might not have lived the day. Think if Richard Jewell had been a Japanese American during World War II, when we decided that the right of habeas corpus didn't apply to you if your parents were from Japan or if your grandparents were from Japan. There was an experiment, I remember, I think in college. It's a psychology experiment, and they put a patient or a person in a room, and they said, this person has information, and we're going to shock them just a little bit, and here's the dial. You get to decide. And they wanted to ask, how high would people turn up the dial? And it was pretty scary that a good amount of people that you would imagine are normal, respectable people, how high they would turn the dial to shock somebody or to torture somebody. See, we think that wouldn't happen, but it does. And anytime you make an analogy to horrific people in history, a Mussolini or a Hitler, people say, oh, you're exaggerating, you're talking about, it's hyperbole. And maybe it is, and particularly to accuse anybody of that is a horrific analogy, and I'm not doing that. But what I would say is that if you are not concerned that democracy could produce bad people, I don't think you're really thinking this through too much. And that if you're not concerned about procedural protections are how evidence is gathered, how evidence is taken from your house, what rules the police have to obey. And people don't quite get this. We don't have a mature discussion on this. Because anytime we try to say, well, this is to stop someone who could be a bad policeman, the media dumb it down and say, you're saying policemen are bad. No, it's the opposite. 98, 99% of policemen are good. In fact, of the general public, it's pretty close to that. But the thing is, you have the rules in place for the exception to the rule. And so you have these procedures in place because maybe it isn't tomorrow we decide that we're going to round up all the Japanese Americans again and put them in internment camps. But maybe next time it's Arab Americans. So the thing is, we have to be concerned with this because you don't know who the next group is that's unpopular. The Bill of Rights isn't for the prom queen. The Bill of Rights isn't for the high school quarterback. The Bill of Rights is for the least among us. The Bill of Rights is for minorities. The Bill of Rights is for those who have minority opinions. The Bill of Rights is those who are oddballs, those who aren't accepted, those who have unconventional thinking. But if we are so frightened that we're going to throw all the rules out and we're just going to say, here's my liberty, take it. Here are my records. I didn't do anything wrong, so I don't mind if you look at all my records. If you say the standard will now be, if I have nothing to hide, I have nothing to fear, look at everything I do, there will be a time and there will be a danger that in giving up your freedom, giving up your privacy, that you'll find that the world you live in is not the world you intended. There have been good folks within the National Security Agency who have talked about and have pointed out that we've gone too far. Bill Binney was one of those. He was a high-ranking NSA official who decided that they had gone too far. There was an interview, it's probably been a year or two, with Bill Binney that was in Frontline. And one of the first questions was, what a lot of people in government will say is that you don't understand, we're still at war. Remember, we lost 3,000 people on 9/11. This is a very important program, talking about the warrantless collection of all our records. It has saved thousands of lives, as Cheney said at one point. There are multiple plots that have been stopped because of this program. You've got to be very careful about what you wish for, because if you do, you might have another attack. You might have blood on your hands. Fear. What is your reaction to this question about the effectiveness of what has been done? Binney replied, first of all, they like to lump it in as one program and say you can't cancel the program. In fact, Binney was famous because he'd been working on a program that did investigate terrorists but protected American information and deleted American information from incidental collection. So he said it's false to begin with. It's multiple programs. The one program that dealt with domestic spying was called Stellar Wind. Stellar Wind was one that was created also by executive order and was done without the permission of Congress before the Patriot Act. They had the other foreign ones. You mentioned the names. There were other names that were listed in the PRISM program that were dealing with foreign intelligence. There were a whole bunch of these programs, not just one. So the point is that you stop the intelligence, the domestic intelligence program, period. So Binney's opinion was, and this is a guy who wrote a lot of the original programs, Bill Binney said he would continue gathering the information on foreigners. This is a guy who worked for 30 years for the NSA. He's not some dove who doesn't want to do anything about terrorists. Bill Binney worked for 30 years to develop the programs that help us catch terrorists, but he felt like it wasn't proper or constitutional to collect Americans' records without a warrant. He said, if we get incidental records, destroy them. Don't collect them. He says, eliminate them. The records of Americans are irrelevant to anything that the incidental collection that is going on. All the terrorists would have been caught by the process that we put in place for Thin Thread. Thin Thread was a program that they had before they went to the unconstitutional program. It was looking in and focusing in on the groups of individuals that we already had identified and anybody in close proximity to them in the social graph, plus anybody. The other simple rules, like anybody that was looking at jihadi websites, etc. That would get them all, and you didn't have to do the collection of all this other data that requires all that storage, transport of information to the storage, maintenance of it, interrogation programs, all of that added expense that they're incurring as part of it over the last 10 years. You wouldn't have had to have any of that. Frontline then asks, this problem of haystacks, how big a problem is it? Is that what we've done? Is we've created a situation where the haystacks are bigger and it's almost impossible to find? This is Frontline's question, and it's a question I've been asking also. If you collect all of Americans' records all the time, if we collect all of your phone records, can we possibly look at them? Now, computers are getting better, but still there has to be a human involved. I think we're overwhelmed with the data. At one point in time, about a year ago, I remember an article where I think they'd collected millions and millions of audio hours. They've just been collecting. They're siphoning, they're vacuuming up everything. And I think they'd only been able to listen to about 25% of it. So the thing is that there is some information that we need to get and we should get. When the Sonarif boy, the Boston bomber, goes to Chechnya, we needed to know that. We needed to continue to see if there was evidence that we could take to a judge to continue to investigate him. So we do need surveillance, but what we don't need is indiscriminate surveillance, and we don't need the haystack to get so big that we can never find the terrorist in the stack. Binney responds, well, what it means simply is you use the traditional argument, they say, we're trying to find a needle in the haystack. It doesn't help to make the haystack orders of magnitude larger because it makes orders of magnitude more difficult to find that needle in the haystack. Frontline. And is that what they've done? Have we made the haystack so large that we're actually having more trouble catching terrorists because we're scooping up and swooping up all of America's data? Binney, that's what they've done. And now they're looking at things like game playing and things like people doing that. I mean, this is ridiculous. How relevant is that to anything? Frontline. But they say they're computers, and in Utah, they're going to be able to take all this stored data, and they're going to be able to go through all of it, and they're going to be able to connect the dots. Connect the dots. That's what everybody wanted them to do after 9/11. Bill Binney, the former senior NSA, see, that's always been possible. Before 9/11, we were doing that. That was already happening. We already had that program. That wasn't an issue at all. That's why we should have picked this out from the beginning. We should have implemented it, this Thin Thread program that he'd already been working on, connect the dots, everything in the world, but we didn't. That's why we failed. It wasn't a matter of not having the program. It was a matter of not implementing what we had. When 9/11 came, We gave medals to the heads of our intelligence agencies. No one was ever fired. And yet the 20th hijacker was caught a month in advance. Moussaoui's caught in Minnesota for trying to take off planes but not land them. The FBI agent there wrote 70 letters to his superior trying to get a warrant. It wasn't that we had to dumb down and take away the procedural protections of warrants. The warrant wasn't denied. They'd have a much stronger argument if they could say, well, we tried to catch the terrorists, but the judges kept saying no to warrants. It's absolutely not true. They didn't ask the judge for warrants. So the 70 requests in Washington sat at FBI headquarters and weren't requested. You also had another hijacker in Arizona training to take planes off. Once again, the FBI agent there doing a great job in sending the information to Washington and people not talking to each other. It had nothing to do with saying the Constitution is too strong. We have to weaken the Constitution or we'll never catch terrorists. It had nothing to do with that. But that's precisely the argument we had. In the aftermath of 9/11, the PATRIOT Act was rushed to the floor. Several hundred pages. Nobody read it. Didn't come out of the, there was one out of the committee. They didn't use that. They rushed a substitute to the floor, and no one had time to read it. But people voted because they were fearful, and people said there could be another attack, and Americans will blame me if I don't vote on this. But we're now at a stage where we should say, are we willing to give up our liberty for security? Can you not have both? Can you not have the Constitution and your security? I think you can. Several agents other than Bill Binney have also said, several national security officials, that the powers granted the NSA go far beyond the expanded counterterrorism powers granted by Congress under the PATRIOT Act. The court now agrees with that. And anytime someone tries to tell you that metadata is meaningless, don't worry, it's just who you call, it's just your phone records, it's not a big deal. Realize that we kill people based on metadata. So they must be pretty darn certain that they think they know something based on metadata. Now, these are ostensibly or presumably terrorists that are being killed, but what I would say is that if they're killing people based on metadata, I would think you would want your own metadata pretty well protected. To give you an example of how representatives are sometimes getting it right, in the House of Representatives, they have seen and responded to the people. Thomas Massey and Representative Lofgren introduced an amendment to the Defense Appropriation Bill last year. This amendment would have defunded the warrantless backdoor searches, what they're doing through 702, which is an amendment to the FISA Act. This is where we say we're investigating a foreigner, but the foreigner talks to an American who talks to other Americans, and it ripples out into enormous amounts of incidental information. The information from 702, when you analyze it, 9 out of 10 bits of information that are collected are not about the person we've targeted. They're incidentally collected about other individuals. But when Representative Massey and Representative Lofgren introduced their amendment to defund the backdoor searches and to tell the CIA and NSA that they cannot mandate that companies give a backdoor entry into their product, the amendment passed 293 to 123. But just to show you that no good deed goes unpunished, and just to show you the arrogance of the body, the vast majority of people don't want their phone records collected without a warrant. But what did they do when this passed 293 to 123? They stripped it out in secret in conference committee, and it was gone. And the reason it was gone is like everything else around here. You wonder why your government's completely broken? We lurch from deadline to deadline, and it's on purpose, really. We do deadline to deadline because it's in, we got to go. It's spring break. We're going to be late for spring break, and we've got to go, so we've got to finish this up before we go. It's how the budget is done. So no one ever votes on whether we're going to spend X or Y. They put the whole budget into 2,000 pages. Nobody reads it. It's placed on our desk that day. Nobody has any idea what's in it. None of your concerns about your government are ever addressed. We just pass, boom, the whole thing, and it's out the door. It's the same way with these kind of things. Because there's a deadline, and this amendment was passed, 293 to 123, saying that we shouldn't fund these illegal searches and that we should stop the bulk collection of records. It's passed overwhelmingly, and yet in secret, somehow it's taken back out of the bill and never becomes law. Now, while I don't agree completely or really at all with the reform that's come forward out of the House, it's at least evidence that they're listening. They have a bill that would end the bulk collection of records, but replace it with, I think, maybe another form of bulk collection. But it passed overwhelmingly, 330 some odd votes. But you know what you hear when it gets over here? They say the Senate is distant more from the people and not as responsive. Absolutely true. And sometimes to the detriment of the public. Because the thing is that while it's overwhelmingly popular with the American people that we shouldn't be collecting your phone records without a warrant with your name on it, and the House has recognized this and passed something overwhelmingly to try to fix it, the first thing that I hear over here from people is, well, we're not collecting enough of your phone records. They're disappointed that the government isn't getting, they have access and they claim they can gain access to everything, but the government's really not collecting all of it. So people over here are disappointed. They want to collect more. So the American people say, enough's enough. We want our privacy protected. We want the government to take less of our records. Congress recognizes that, the House of Representatives. Then it comes over to the Senate, and the Senate says, oh my goodness, we want to collect more of your records. We don't think we're getting enough into your privacy. We don't think we've completely trashed the Bill of Rights enough. Let's try to gain more of your records. One of the other things that the Massey-Lofgren Amendment that did pass over there, was to get rid of and say that no funds would go to mandate or request that a person alter his product or service to permit electronic surveillance. Because, see, this is what's going on, and it is pretty nefarious and really, I think, antithetical to freedom, is that our government is telling companies like Facebook and Google and these other companies, they're forcing them to let the government have access into their product. Well, everybody knows this is going on. It's no secret, and it's killing these companies in their worldwide market because non-Americans don't want to use our email. They're afraid the government has forced their way into all their transmissions. There's currently another bill in the House put in by Representatives Pocan, Massey, Grayson, and McGovern that would repeal the entire thing, repeals the Patriot Act and FISA amendments of 2008, permits the court to appoint experts, permits the courts to have appeal, basically tries to make our intelligence courts a little bit more like an American court or American jurisprudence. EPIC is the Electronic Privacy Information Center. And they talk some about these national security letters that I mentioned earlier. National security letters, there are now hundreds of thousands of these. And these are letters that are not, they're warrants. They're not signed by judges. They're actually signed by the police. And this goes against sort of the fundamental precept of our jurisprudence, the fundamental aspect was that we divided police from the judiciary. And it's supposed to be a check and balance in case the local policeman had some sort of bias. They always had to call somebody else. It's not perfect, but it's a lot better than not having a check and balance. So when we got to NSLs, this comes out of the Patriot Act. They start out with a few thousand, they grow and grow and grow. Now there's hundreds of thousands of them. But realize that the national security letter is similar to what we fought the revolution over. We fought the revolution over writs of assistance, which are basically generalized warrants, but they were also written by British soldiers. And we were offended, that a soldier would come into our house with a self-written permit. A lot of the reaction and the reason we wrote the Bill of Rights the way we did is that we were concerned with British abuses. We were concerned with the idea of general warrants. So when we wrote the Fourth Amendment, we said that it had to be specific to an individual. We said that you had to name the individual. And that's one of the real problems with the bulk collection of records, is that they're not really based on suspicion of an individual, because basically the government is collecting all of your records indiscriminately. The government's not even obeying the loose restrictions they put in place. So the Constitution says you have to have probable cause. You have to present some evidence to a judge. You don't have to prove that they're guilty, but you have to have enough evidence that the judge says, it looks like that person could be guilty of a crime. So with the Patriot Act, we lowered that standard, and we then lowered it again. For collecting information under the Patriot Act, all you have to do is say that the information you want is relevant to an investigation. Well, when this gets to the court basically says this is absurd. So 2 weeks ago, the court just below the Supreme Court says it is absurd to say that every American's phone record is somehow relevant to a terrorist investigation. They said that it takes the meaning of the word relevant and basically destroys any concept that the word has meaning at all. So the Patriot Act went to a much lower standard, not probable cause, but just that it might be relevant to an investigation. And even with that lower standard, the court said, that's absurd. So the president, how does the president respond? The president responds by doing nothing. The president could end this program tomorrow. So every one of your phone records are being collected without suspicion, without relevance, in contradiction to even what the Patriot Act says. Your records are being collected. The second highest court in the land has said this is illegal, and the president does nothing. The president says to Congress, oh yeah, I'll do it if Congress will do it. Well, it's a bit disingenuous, Mr. President. We didn't start the program. The authors of the Patriot Act had no idea this was going on. And the Patriot Act, according to the court, doesn't even justify this. So we're looking at telephone records. We're looking at email records. EPIC, the Electronic Privacy Information Center, has another big complaint about this, that people were put forward and then told that they couldn't even talk about the fact that they've been given a warrant. They were threatened with 5 years in prison for even mentioning that they'd been served a warrant. This, I think, is an obvious contradiction to the First Amendment. So we have legislation that contradicts the Fourth and the First Amendment. The national security letters in 3 years, from 2003 to 2005, these are the warrants that are written by FBI agents, not written by a judge. There was 143,000 warrants given out in our country to Americans without a warrant, with a warrant written by the police. The New York Times has talked about this, and Charlie Savage, in a report last year, reported that the Justice Department had to apologize to a federal appeals court for providing inaccurate information about a central issue in a case challenging the constitutionality. Now, what is truth and what isn't truth? When you go to a court, it's like when your kids fight. There's two sides to everything. One child has one argument, and the other child's got the other argument. The truth is listening to both sides and trying to figure out what the truth is. The court is no different. But in these courts, you're only hearing one side. Only the government represents their case. So if the government says that we want all of the phone records because they're relevant, no one stands up on the other side and says, I object. That's one of the reforms that Senator Wyden and I have talked about, is having somebody represent the accused, somebody to stand up and say, maybe all the phone records in the country are not relevant. Maybe they're not relevant to an investigation. It would be absurd to say every American would be relevant, or that every American's records would be relevant. Probably no one in America knows more about this subject than Senator Wyden, who I see has come to the floor. Senator Wyden knows more about this because he's been on the Intelligence Committee for several years. And there's two tiers within Congress. There's a great deal of information that I am never told. Even though I was elected to represent Kentucky, I'm not allowed to know a lot of things that happens in the Intelligence Committee. Now, the downside for Senator Wyden is he's allowed to know more, but then he's not allowed to talk about it, which makes it a problem because it's hard to have dissent in our country. If I'm not given the information, how can I complain about it? And if he's given information and then not allowed to complain about it. So these are the things we struggle with in trying to find truth.
Would the senator from Kentucky yield for a question without losing his right to the floor?
Yes.
I thank my colleague, and it is good to be back on the floor with him once again on this topic. And as we have indicated, this will not be the last time that we are back on the floor. And my colleague has made a number of very important points already. I was especially pleased my colleague brought to light something that is little known, that the Attorney General of the United States is interested in, the FBI director is interested in requiring companies to build weaknesses into their products. In other words, we have had companies interested in encryption, as my colleague has mentioned, and what's happened as a result of that encryption, they had a chance to start getting the confidence of consumers, both in the United States and worldwide, back. And then the FBI director has been interested in effect, requiring companies to build a backdoor into their systems. And this, once again, kind of defies common sense, because the keys won't just be out there for the good guys. They will also be available to the bad guys. And I'm very pleased that my colleague from Kentucky highlighted one particular new development in this debate. And I have sought, as a member of the Intelligence Committee for some time, to come up with an approach that once again demonstrates that security and liberty are not mutually exclusive. We can have both, but we're certainly not going to have both, as my colleague touched on in his statement, if the policy of the FBI director is to require companies to build a backdoor into their products, build weaknesses into their products. Now, the senator from Kentucky is very much aware that my staff and a number of senators are currently working through a number of issues and amendments related to the question of how we can pass trade legislation and get more family wage jobs for our people through exports. And a number of us, myself specifically, have been concerned that the majority leader and other supporters of business as usual on bulk collection of all of these phone records would somehow try to take advantage of our current discussions and try to, in effect, sneak through a motion to extend Section 215 of the USA PATRIOT Act. As long as the senator from Kentucky has the floor, that cannot happen. And my hope is once our colleagues have agreed on a path to go forward with job-creating, export-oriented trade legislation, it will be possible to resume our work on that very important bill. In the meantime, my question for my colleague pertains to an issue that he noted I have been at for some time. As my colleague knows, I have been trying to end the bulk phone record collection program since 2006. And the reason I have is that what this bulk phone record collection program is a federal human relations database. When the federal government knows who you've called, when you've called, and often where you have called from, which is the case certainly if somebody calls from a landline and someone has a phone book, the government's got a lot of private and intimate information about you. If the government knows that you called a psychiatrist 3 times, for example, in 36 hours, twice after midnight, the government doesn't have to be listening to that call. The government knows a whole lot about what most Americans would consider to be very private. So this has been an important issue. My colleague from Kentucky has been an invaluable ally on this particular cause since he arrived in the Senate. And I just want to give a little bit more background and then get my colleague's reaction to this question. I've seen several of my colleagues come to the floor of the Senate talking about why we ought to keep bulk phone record collection. And the statement has somehow been that this is absolutely key for strong counterterror. That is a baffling assertion, I would say to my colleague from Kentucky, because even the Director of National Intelligence and the Attorney General are saying that it isn't. So what we have is members of the Senate saying that bulk collection, some of them, ought to be preserved in order to fight terror, and the Director of National Intelligence and the Attorney General, 2 individuals who are not exactly soft on terror, saying that it's not. Now, if senators and those who might be following this debate are seeking a more detailed analysis, I hope that they'll check out the very lengthy report on surveillance that was issued by the President's Review Group. This group's members have some very impressive national security credentials. I mean, these are not people who are soft on fighting, terror. One of them was the senior counterterror advisor to both President Clinton and President Bush. Another served as acting director of the CIA. And this review group, a review group led by individuals with pristine anti-terror credentials, said on page 104 of their report, staff sometimes kids me, I'm sure this is the case for the senator from Kentucky because I always say page 104, I'll quote here, "The information contributed to terrorist investigations by the use of Section 215, bulk telephony metadata, was not essential to preventing attacks and could readily have been obtained in a timely manner using individual Section 215 orders." So what this distinguished group of experts said supports what the senator from Kentucky is saying, what I and others have been saying for some time. So the senator from Kentucky, pointed out my service on the Intelligence Committee. I think Senator Feinstein and I are two of the 5 longest-serving members in the committee's history. We didn't find out about bulk collection until it had been underway for quite some time, because it was concealed from most members of the Intelligence Committee for several years. But given the fact that we began to see in 2006 and early 2007 what's at stake, this has been a fight that has been going on for 8 years. And one of the reasons, an additional reason, that I appreciate the senator from Kentucky being here now is that for these 8 years and multiple reauthorizations, it's always been the same pattern. It was almost like the night follows the day. Those who are in favor of dragnet surveillance and those who are in favor of the bulk collection program, in effect, wait until the very last minute. They wait until the last minute, and then they say, "Oh my goodness, it is a dangerous world. We've got to continue this program just the way it is." Well, I tell my colleague from Kentucky, and I know he shares my view on this, there is no question that it is a very dangerous world. Anybody who served on the Intelligence Committee, as I have for more than 14 years, and goes into those classified meetings, weekly, does not walk out of there without the judgment that it is a very dangerous, world. But what doesn't make sense is to be pursuing approaches that don't make us safer and compromise our liberties. That's what doesn't make sense. And so last year, along with my colleagues, Senator Heinrich and Senator Mark Udall, I filed a brief in a case that was before the Court of Appeals for the Second Circuit. It's an important court, one of the highest in our country. In the brief, we said, and I quote, "We have reviewed this surveillance extensively and have seen no evidence that the bulk collection of Americans' phone records has provided any intelligence of value that could not have been gathered through means that caused far less harm to the privacy interests of millions of Americans." And I'd say to my colleague, what we are talking about are, in effect, conventional approaches with respect to court orders, and then there are emergency circumstances. Emergency circumstances, so when the government believes it has got to act to protect the American people, it can move quickly and then, in effect, come back and settle up later. But the conclusion that we reached after reviewing bulk collection very carefully was based on 8 years worth of work. And of course, we've recently had this court declare bulk collection to be illegal. So my first question is, does the senator from Kentucky agree that there is no evidence that dragnet surveillance now makes America any safer?
Well, I think it's a great question, and I think it's also very difficult to prove these things one way or another sometimes, and we're at a great disadvantage because a lot of times they hold all of the information. So I think it was nothing short of miraculous that you and others were able to investigate this and show that in reality, all of these folks that they allege could have been caught would have been caught through traditional surveillance, through traditional warrants. And I think this is a pretty important point, because they want us to live in fear and give up the Fourth Amendment, but it turns out even the practical argument isn't an accurate one, because it turns out that almost always, if not always, the terrorists seem to be caught through sort of the normal channels of human intelligence, suspicion, finding something out about them that causes us to investigate them. And I, like the senator from Oregon, do want to catch terrorists, and I also want to keep our freedom at the same time. And I think it was a pretty important conclusion, not only by the review board, but also by the the Privacy and Civil Liberties Oversight Board as well, the review panel, two groups of folks from the administration. And one question that I would be interested in also from the senator from Oregon is, in an op-ed in December, Senator Wyden wrote in the LA Times that building a backdoor into every cell phone, tablet, or laptop means deliberately creating weaknesses that hackers and foreign governments can exploit. But I would be interested in entertaining a question concerning that.
I apologize to my colleague. Could my colleague just restate that briefly?
This was in an op-ed that was written by the senator from Oregon in LA Times in December, and I'm quoting from the op-ed. It says, building a backdoor into every cell phone, tablet, or laptop means deliberately creating weaknesses that hackers and foreign governments can exploit. And I think expanding upon that in the form of a question, I think would help us to understand exactly what you mean by that.
What the senator is asking about is a statement made by the FBI director, Mr. Comey, and it was not some hidden kind of articles on the front pages of all our papers, that really deserves, as my colleague is suggesting, some consideration. In fact, one of the last things I did as chairman of the Senate Finance Committee, had a relatively short tenure there in 2014, was to hold a workshop in Silicon Valley on this issue. And the problem stems from the fact that with the NSA overreach taking a huge toll on our companies and the confidence that consumers both here and around the world had in the privacy of their products, these companies said, we've got to figure out a way to make sure that consumers here and around the world understand that we are going to protect their privacy. So they decided to put in place products that had strong encryption. They felt that that was important to be able to assure their consumers that when they sold something, that their privacy rights were protected. And in doing so, of course, they also made it clear that, as has always been the case, when the government believes that an individual could put our nation at risk, you get an individual court order, you use emergency circumstances, and you could still get access to information. And the response by our government, which contributed mightily to the problem by the NSA's overreach in the first place, was our government saying, nope, you're not going to be able to use that encryption to bring back the confidence that Americans have in your products and people around the world. And there were projections, I would tell my colleague, that these companies were already losing billions and billions of dollars in terms of the consequences of loss of privacy. The response of the government was to say, we are looking at requiring you to build weaknesses in your products and, in effect, create a backdoor so we can get easy entry. And I know at town hall meetings at home in Oregon, I've talked about the concept of our government requiring companies to build weaknesses in their products And people just slap their forehead. They say, what's that all about? It's your job to make sure that we have policies that both secure our liberty and keep us safe. It's not your job to tell companies to build weaknesses into your products. In effect, you're going to just throw up your hands and say, we can't do it. So the company ought to build weaknesses in the products. And as my colleague said, I pointed out that once you do that, it won't just be the good guys who will have the keys. It'll be bad guys who have the keys at a time when we are so concerned about cybersecurity. Might I ask my colleague another question on one other topic he and I have talked about at great length? Is the senator from Kentucky troubled by the fact that a number of high-ranking intelligence officials have not been forthright in recent years with respect to this bulk collection and the collecting of data on millions or hundreds of millions of Americans? My colleague knows I've been particularly troubled by this, and I ask the question because my colleague and I have pointed out that we have enormous admiration for the rank and file in the intelligence field. These are individuals who day in and day out get up in the morning and contribute enormously to the well-being of the American people. And we have enormous respect for them. We are grateful to them. They are patriots, and they serve us every day well. I personally do not think they have been well served by the fact that a host of high-level intelligence officials have not exactly been straight or forthright with the Congress and the American people on these issues. And I would be interested in my colleagues' view on that, because we have discussed this at some length, and I'm glad to be able to put it in the context of making sure that Americans know that the two of us greatly respect the thousands of people who work in the intelligence field, serve us well, do the things that are necessary to apprehend and kill bin Laden, but that we are concerned about the question of the veracity, the forthrightness of some of the members of the intelligence community at the highest levels. What's my colleague's reaction to that?
I think the vast